Imagine a scenario where a person's entire life, their name, and their motive for entering a relationship are fabricated. A profound moral deception has occurred, yet the state recognizes no crime. This legal contradiction is anchored in the 2018 High Court case of R. Monica v. Director of Public Prosecutions. The case exposes a strict reality within the UK. The legal threshold required for deception to invalidate or vitiate sexual consent is exceptionally narrow. Look at the facts of this case. The state deployed undercover police officers to infiltrate and monitor activist groups. Over the course of their deployments, several officers formed intimate, long-term sexual relationships with the activists they were investigating. The officers lied completely about their names, their occupations, and their core identities. The lives they presented to their partners were wholesale fabrications. Despite the devastating personal impact on these activists when the truth eventually surfaced, English law does not automatically classify these actions as rape or sexual assault. Why does a multi-year fabrication of a person's existence fail to cross the threshold of legal fraud regarding consent? The Monica ruling forces us to separate moral outrage from the strict mechanical definitions of criminal law. The Crown Prosecution Service was tasked with determining whether criminal charges should be brought against these undercover officers. Following their investigation, the CPS formally decided not to prosecute the officers for sexual offenses. One of the activists, identified in court documents as the claimant Monica, responded by launching a judicial review against the CPS decision. She argued the prosecutors had misapplied the legal test for what constitutes valid sexual consent. This battle over legal definitions arrived at the High Court. The judges were not holding a criminal trial for the individual officers. They were examining the underlying legal logic the CPS used to drop the case. The impending decision would serve as the ultimate stress test for the modern definition of sexual consent in English law. The High Court ultimately dismissed the claimant's case, siding with the CPS. Lord Burnett and Justice Jay affirmed a clear, consistent line of legal authority that heavily restricts what types of lies count as actionable fraud. The court identified two strict categories of fraud capable of vitiating consent: the nature of the act and impersonation. The first applies when someone is deceived about the physical mechanics of what is occurring. The second covers fraud as to identity, categorized strictly as impersonation. In a legal context, impersonation does not mean adopting a fake persona or lying about your background. It strictly requires masquerading as a specific known individual, such as a victim's husband or established partner. Because the undercover officers invented entirely new identities rather than stealing existing ones, they did not commit legal impersonation. Under this rigid two-pillar framework, creating a wholesale fictional life falls completely outside the bounds of criminal fraud. To establish this boundary, the High Court relied heavily on historical precedents, specifically citing the cases of Geetha and Lineker. Case law strictly separates the circumstances of a meeting from the nature of the intercourse. Circumstances covers lies told to initiate sex, including false wealth, jobs, and names. The nature category strictly requires understanding the physical reality of the act itself. The court concluded that while the claimants were heavily deceived as to the situation they found themselves in, they were not deceived as to the physical nature of the act they were engaging in. The judiciary is highly reluctant to merge these categories. If circumstantial lies invalidated consent, vast amounts of unethical but historically permissible conduct would suddenly become criminal. The judiciary firmly views the criminalization of new behavioral conduct as a strict matter for the legislature, refusing to expand the law from the bench. Legal commentary surrounding the case suggests this restrictive ruling is less watertight than it appears. A contrasting line of legal authority exists in the modern precedents of McNally and Wilson. Both of these cases dealt specifically with deception regarding a person's gender identity. This creates a direct split in case law. Left, the restrictive Monica framework; right, the expansive McNally-Wilson framework, where gender deception vitiated consent. This bypassed the nature of the act requirement, yet their identity deception was deemed illegal. Why is deception regarding one type of core identity criminalized, while a completely fabricated life as an undercover officer is protected? The courts have effectively created a two-tiered system of identity fraud. The legal threshold shifts depending heavily on the specific type of identity being lied about. This leaves legal practitioners with immense unpredictability when attempting to advise clients on what constitutes valid consent. The Monica ruling does not sit in isolation. It exists in direct, unresolved friction with modern precedents. Following the Monica decision, the general rule remains highly restrictive. Deception regarding the circumstances of a meeting, no matter how extreme, does not legally vitiate consent. Yet, this general rule is immediately undermined by the specific exceptions carved out for cases involving gender deception. Look at this conceptual map of the case law. English criminal law regarding sexual consent is currently fractured into disconnected islands. The common law framework, relying on judges to incrementally adapt century-old definitions of fraud, has reached its breaking point. If society intends to classify profound identity deception as a sexual offense, it cannot be achieved through piecemeal judicial reviews. Resolving the contradiction between a moral lie and a legal crime now rests entirely in the hands of Parliament. It requires a statutory rewrite of the Sexual Offences Act.